viewers to the Personal Injury Law Show. This is a show that talks about everything current in the law of personal injuries and obviously of relevance to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer of 25 years experience. With me tonight I've got Don Maffia, a partner in the law firm in Transport Accidents. Good evening, Don.
Good evening, Tony. Good evening, viewers.
And Anna Hall, a lawyer in Transport Accidents in the law firm. Good evening, Anna.
Good evening, Tony. Good evening, viewers.
Viewers, tonight we've got a must-see episode updating you on transport accident laws, cases and legislation, so stay tuned for that.
However, Tony, firstly, what's in the news?
Viewers, there's been a lot in the news, but we've got this ongoing saga at the Wunderlich factory, Don.
Yeah.
An asbestos victim launches a suit. This is in Sunshine, mind you, right in the heart of the city.
Yeah, we're
tell us a bit more about it.
away
mate.
from residential. Well, it's a cement factory where there was dumping of asbestos like in their backyard of the factory, and there's comments made that even at one stage that there was like 4 to 5 metres of dust, which was
Dust plumes in
which
the
is
air.
yeah, which was the asbestos particles, which has obviously affected 25 people have died or become ill with asbestos-related diseases
Over the years,
Some have gone to mesothelioma, which is, as we know, Tony, is a cancer which is not treatable.
It's not treatable,
it's death. Right. And now there's lawsuits which are starting. So look, we're not going to see the end of this, Tony. This is just going to be, unfortunately, years and years of lawsuits coming out of this.
But the sad thing about this, Anna, is that it was very close to homes.
That's right.
Houses are only about 100 metres away.
Well, that's correct, Tony. One of the current people who's suing for asbestos-related disease lived 125 metres from the factory and had lived there for around 15 years. But there are other people who have already been successful in this litigation, this article suggests, and they've all lived in the local area.
It's fair to say that if you've lived anywhere close to this factory over the years, I'm talking as far back as 1960s, you should get yourself checked out, correct?
Correct. You're at
And
risk.
if viewers have got any queries about this, don't hesitate to ring. Are you surprised to know that there's more deaths from people falling off ladders than what there are on the road, Anna?
Well, DIY, this article suggests, has become a really popular hobby for a lot of people, particularly with some older Australians, and it's noting that yearly they're having about 2,500 people injured from falling on ladders. So when you look at those statistics, it's not hugely surprising.
And Dom, there's a lot of instances where people say, "Oh, can you come and give me a hand?
Yes.
You know, I'm fixing this roof, or I want to put this cabinet, or cornices. Can you give me a hand?" I mean, in those instances, you don't want to let down your mates, but really you should be saying to them, unless we're going to employ safe practices, leave me alone. I'm not getting involved.
Correct. And Tony, a few years ago, Molly Meldrum fell off a ladder and sustained severe head injuries, and he was doing his own. I think he was putting up things for a party or something. But it's interesting. It's saying the comments are that because people are living longer, they may have medical conditions which cause some imbalance or problems with consciousness. So people go up and even get vertigo, fall off. But like Anna said, there's also because of the influence of our TV shows, all the do-it-yourself renovations.
I think it's more of a do-it-yourself renovations because a lot of people that are falling off ladders are younger people that are trying to save $1.
And Tony, if we put it in this way, look at figures. I mean, the road trauma death tolls is around, what, a year, 300?
300, yes.
So obviously ladder falls deaths are more than 300 a year.
Well, there's 2,500 hospitalised each year in Victoria.
Yeah.
And that's just Victoria.
Yeah.
Right.
So it's a big
that's
number.
Yeah.
And also, one of the key things is when you're doing work on a roof or at a height and working on ladders, you should have somebody spotting for you. That is holding the ladder, giving you
Be careful.
guidance.
It's just ultimately, when you're working at heights, it's not the time to cut corners. This is really the time to ensure safety is the number one priority.
Isn't it funny, to save a couple of dollars here and there, you're putting your livelihood at risk, you're putting your health at risk, you're putting your family's livelihood at risk. It's just bizarre, isn't it?
Yeah.
Really. We'll keep moving. We've still got issues about dogs off leashes out in the street, and this young lady lost her ear, Anna.
That's right. This is a matter that occurred in Sydney's West, and a young lady's been attacked by her friend's dog, and her earlobe's actually been mauled by the pets.
It's been torn off.
Yeah, nasty situation, and it really shows you that whilst we love our pets, you do have to be very careful to only get that close to dogs you know and trust and understand.
Don, there's a lot of things that flow from this. One, the dog's going to probably be put down. Two, the owner's going to be prosecuted. But three, importantly to the person that's been attacked, compensation.
Correct. So it's an owner's beware. If your dog gets out and injures someone, you could be liable, you will be liable, And if you don't have insurance, Tony, so some houses and households have insurance, so maybe insurance covers it, but if you don't, then you're personally liable. Out of your own pocket.
Exactly. And also in some policies now, they're actually got exclusions for dogs unless you take out extra coverage. So you'd want to be very, very careful, wouldn't you?
Correct.
Yeah.
Well, you just got, it's just the basic things. Make sure your fences are properly, dogs don't get out, make sure they're locked up. Because as you can see, the dogs get out and we see time and time again, particularly in our industry, Tony, where people are injured and suffer very significant injuries as a result of a dog attack.
In prison, Ravenhall, there's been an absolute disaster. $10 million worth of damage. There's been riots, and it's all to do with passing these new rules that you can't smoke.
It's banning cigarettes in any government buildings, which includes obviously prison housing. So it's caused, as you expect, I don't know what they expected, it would have caused
Carnage.
Carnage. But the thing about this article, Tony, is that the authorities, they were tipped off that there was going to be a riot.
So
the
you're looking
prison
at
guards,
yeah.
and they didn't do anything about it. So they put a lot of the prison guards at risk. And that results, if they were injured, sustained injuries, then that's obviously a work cover claim because the prison guards are part of the work cover scheme. So they will have any compensation paid by work cover, but also if they sustain serious injuries, Tony, they could sue the authorities.
Of course.
Because they knew they should have done more about it.
Well, we've done a lot of cases over the years involving prison guards and people like that getting injured on the job.
Yes.
But how's this? I mean, what would you ban smoking in a prison?
I don't
So,
think it's
you
the
know,
best policy of the government, today's government. I think, if smoking, they're in 24 hours in a prison facility, what else can they do?
All right, now this is disturbing. Disturbing in the sense that the ages of these kids deciding to switch sex are under 18. First stage, what does it entail?
I think first stage suppression of puberty, so I suspect that's more medication. But Tony, we've got to understand that this is a medical condition that they go through. There are clinics set up to help these type of children go from one gender to the other. So we are dealing with a condition. Obviously, kids under 18 cannot consent, so they have to go to the family court to get permission. And
But they're given them permission, John.
and the family court's given them permission. So, but I suspect it's just not giving out permission willy-nilly. There will be obviously a lot of medical treatment behind all that and medical opinions as well, Tony. So, look, in one way, it's good that there is family law permission. We just hope that it stays like that and they're just not giving it out and there is a good basis to do this.
And I think it's under 18's a bit young, but anyway.
Well, there's been
very topical.
25 cases since 2004 that this has been granted in, but it does look like the trend is getting more frequent.
Yep.
In 2015 already, there's been 8 approvals by the family court. So we do see this as something that is becoming
more prevalent.
more prevalent. So.
Viewers, we'll get back to this in due course. It's very topical. We're going to go to a sponsors break. Stay tuned. After the break, we'll bring you up to date with transport accident law. Welcome back to the show. This week we're going to give you an update on transport accident and transport accident cases. Now, we've got this interesting case involving a Colac woman that was run over by her dog.
That's
This
right.
happened in 2014 is the decision, Anna.
That's
Can
right.
you give us the facts?
Sure. So as you said, this woman was in Colac. She had 3 dogs that she was putting into her car. She puts 2 in the back and then she puts 1 in the front seat. Now, in a strange set of circumstances, the dog in the front has stepped on the handbrake. The woman's got caught in the car, dragged, and then fallen under the car and been run over by her car that the dogs are in, and has sustained terrible injuries, which resulted in her having to undergo a hip replacement and bilateral shoulder replacements as well. So nasty injuries, but a very unusual set of circumstances.
Don, why was this a transport accident to start with?
Well, the definition of transport accident in Victoria is an incident directly caused by the driving of a motor vehicle.
Oh, so the engine was on.
Well, the Harky Pit dogs are driving the car.
Well, no,
but
I'm
also
saying-
because of that. But also, it can cover out of control vehicles, and that's why it falls within the scheme in Victoria under the Transport Accident Act.
All right, let's say the engine was not running. In this case, it was.
It still could be a transport accident because of the runaway vehicle, out of control vehicle.
Okay, assuming this was a situation where you're in a driveway that was like that,
Yep.
and you hadn't switched the engine on, you
Yep.
took the handbrake off, and it still rolled down the driveway.
That will still be covered because it's a transport. It's an
Okay.
incident directly caused by the driving, which is a movement, and one would suspect obviously handbrakes are not on. But in this case, it was obviously the out of control vehicle, which entitles the lady to compensation, which includes medical expenses, some wages for lost work up to 3 years. It could go on if the impairment's more than 50%. In this case, she would have been over 50%. But also a lump sum, Tony. And these benefits...
Yeah, the lump sum was pretty big. It was nearly 144,000.
That's
Yeah.
right, and so that means her impairment was way over 50%. Now, it's when they use it in accordance with the guidelines. And we call these benefits no fault because it's a no fault system.
Viewers, this payout's not for common law damages where you sue someone.
We're not suing the dogs.
No.
We're not suing
This
the
is a
dogs.
payout under the no fault system because it's beneficial legislation, and fortunately, because it was a car accident, classified as a motor vehicle accident, she was entitled to the no fault benefits, which is these lump sums.
Correct.
Yeah. And she's left with some pretty nasty injuries.
That's
If
right.
there was a third party involved where someone had actually caused this accident, apart from an animal,
Yes.
you'd imagine that the damages would have been very, very high.
Well, certainly, what's indicated by the payment she's received of nearly $144,000 is that her injuries have assessed
Very high.
under the impairment as very significant. So, if there was a party here that we could sue for common law damages, the plaintiff would have to submit that she's sustained a serious injury, which, when you're
Well, she has.
looking at a hip replacement and bilateral shoulder replacements, you know, we pretty confidently say that's going to be a serious injury. So, in the event that this did have a party that we could sue for negligence, that would be the process this one would take.
And Don, if there was common law in this, what's the maximum you can get under the Transport Accident Act, roughly?
For pain and suffering,
Yep.
it's up to $510,000 as of the 1st of July.
And loss of income?
And loss of income is over $1 million as of
Okay.
the 1st of July. And
Okay.
so this case just goes to show, even if there's no one at fault, you can receive substantial, I won't use compensation, but more benefits from the TAC. It's always good to get legal advice. Again, even if the dog caused the accident, you can still be entitled to compensation. Or
She's still got the dog? No, it's
We
a
don't.
dog. No.
Be in the doghouse.
No, she's still got the dog. She's in the doghouse, all right? All right, let's get on to the next case. This one, this is an interesting case. It's a matter of Aquilina and Transport Accident Commission 2015 decision. Now, this is to decide whether it is a transport accident. Anna, do you want to give me the facts again on this one?
Sure. Aquilina is a very interesting case. This revolved around a man, Mr. Aquilina, who had parked his car in St Albans in 2007. And he goes and gets in his car and turns the ignition on, is what his
That's what
recollection
he
is.
alleges that.
And this resulted in an explosion in his car and he sustained burns to his hands and face. Now, the TAC took 2.5 years to accept his claim as a TAC claim.
That it was a transport
Accident claim, yeah. And then he was put onto payments and received medical and like expenses. Then the TAC had a review and got a report from a Melbourne Fire Brigade, the
Can I
MFB.
stop you there for a minute?
Sure.
Anna? Dom, he turned the ignition
Yep.
and he alleges it exploded.
Correct.
Well, it sounds like someone put a bomb in the car.
Well, that was the issue. What had to be determined is whether or not is an incident directly caused by the driving of a motor vehicle.
Well, if he's turning the
was he
engine
driving?
on, if he's turning the engine on, that's in the act of starting the car.
Well, at first instance, so that went before the Victorian Civil Administrative Tribunal, and then it was appealed to Supreme Court before
All right,
a
what
civil
happened in
judge.
the first instance?
Well, they said there was two issues: was he driving, and then was the
Was it in the
injuries
driving motor
caused by the driving? And the injuries sustained. So, like Anna was saying, TAC eventually got a Melbourne or a fire brigade officer to give a statement, and he investigated the car. He wasn't the expert, but he came to the conclusion that the fire had started in the boot, pretty much. It was a
So-
panel van, so it couldn't have
There was
started
accelerant.
for accelerant.
Yeah.
He concluded that there was accelerant put in the back, and the ignition didn't start the fire. So what the tribunal did was, at first instance, said it was driving. He was driving, but obviously the driving didn't cause, determining ignition was not a cause of the fire.
Okay, went to the Supreme Court of Victoria. What happened there, Anna?
At the Supreme Court of Victoria, they had to review the VCAT decision and look at whether the findings made by VCAT were correct. It was held that this was fine for VCAT to make this decision regarding the findings on driving and the causation of the fire.
Well, the applicant didn't bring any expert evidence.
No.
Did he, Don?
Oh, well, the case was, the way it was presented to the tribunal and obviously subsequent to the Supreme Court was there's two witnesses. You had the driver, Mr. Aquilina, who said, I turned ignition, there was an explosion, and then you had this fire
Mr.
brigade
Conway.
officer, Conway, who turns around and said, well, no, when I inspected it, there was a fire, but more likely caused by accelerants put in the boot. So it was maybe a coincidence between the ignition and the lighting. No one knows. There was no witnesses, but the tribunal, which subsequently the Supreme Court accepted, was the evidence of the fire brigade officer.
Don, in the absence of any other contrary opinion, this applicant was never going to win. Because Conway's the expert.
Well, there was no evidence to contradict.
No, I'm saying,
Yeah.
if you're running this case, would you have got an expert that's contradict what Mr. Conway had to say? The expert?
Ideally what you want to do is have an expert look at the car before it's been repaired or anything. So that's why we keep saying this show, Tony. The first thing to do is try and save the evidence. Because issues like this, 2.5 years later, and then subsequently when it was heard by the court, it was many, many, many years later.
but
The car's no longer existent. The evidence is just going to be based on the evidence of third parties that are
But
obtained.
the fire brigade member, Mr. Conway, had inspected the vehicle, obviously, and found the fire accelerant in the boot.
He'd seen it after it had been moved to another location.
Yep.
So it was sometime after the event
Okay.
that
Okay.
he analysed the vehicle.
All right, Don, you made a good point. Get the evidence early because later on it's going to be very, very hard to piece together.
Tony, many years ago I was involved in a similar case with a car explosion. The first thing you had to do is just save the evidence and get someone out there to take photos to look at it and see how it's caused. Because once you start transporting the vehicles and then have to look at getting repaired and insurers come out, the assessors come
jigsaw
out.
puzzle.
It's like a jigsaw puzzle, put it all back together. So if the evidence is there, hold on to it, get someone out there to have a look
Preserve
at
the
it.
evidence. It's what they do in a crime scene.
Exactly.
Okay. Viewers, we've got to go to a sponsors break. Stay tuned. We'll be back with some further decisions after the break. Viewers, welcome back to the show. We've got a couple more cases we want to discuss with you. The first one's Davies and Nelson and Transport Accident Commission, 2014 Victorian County Court decision, which went to the Court of Appeal. Anna, do you want to give me the facts of this one?
Davies and Nielsen and the TAC is a matter that concerned an accident from 1995. Miss Davies was a driver in a middle car in a 3-car pileup. She sustained injuries to her low back, her left knee and psychological injuries, and she brought her serious injury application to the County Court 19 years after the accident. Now, ultimately, that process called the originating motion, that lost because the judge found that the injuries weren't caused by the accident.
19 years. That sounds like a long time down the track. I didn't even know it was possible to have a claim that long on foot.
Well, they also have to seek time, extension of
Extensions.
time from the court.
Okay.
But Tony, for the viewers, you've got the serious injury. A serious injury is what allows a person, if they have a serious injury, to recover or to sue for their damages. And the definitions of serious injuries are 30% or more impairment, or if you prove to a court, in this case, which Davies was trying to do, you've got a serious long-term physical impairment.
Well, long-term impairment of body function, which gives rise to serious consequences.
Correct.
Well, serious consequences can be you taking medication, having operations, affecting your work.
Well, the test is they have to be at least very considerable when compared to the range of possible impairment. So there's always a range. So she brought her case before the courts, and the issue only dealt with was whether or not she had a serious injury.
Okay.
So the judge at first instance says she doesn't because of causation. And causation means that he did not relate her current symptoms to the transport accident.
It was a pretty severe impact, wasn't it, Anna?
Yeah, it was.
And a lot of the problems that stem from this were the fact that the treating doctor's notes weren't clear cut. They were a bit equivocal on the issue of what the injuries were.
Well, that's right. There weren't very much, if any, complaints until later on, a couple of years later on, about the injury was her back and her knee, but there wasn't very direct evidence after the accident about the injuries.
Just on that issue there, over the years, I mean, practicing 30, I found that a lot of people, and looking at notes, go to doctors, and I don't know if doctors are always taking down everything that the person says, because I've had a lot of clients over the years in particular complain of, say, a foot injury, and then a back pops up as a serious injury 12 months later, and there's no reference to the back in the notes. So is it possible that, you know, because of the fact that they're working under so much pressure and speed, that they don't document things?
Well, Tony, how often do we hear from clients that they say, I've complained to my doctor, but there's no record of it?
Exactly. And Anna, I had one years ago where a person had a damage to an Achilles tendon. Then 12 months later, there was the issue about the back that wasn't in the notes, and the doctor can't remember if he complained of the back, and it really causes problems. But we're very fortunate that we got a very helpful court that found for the person. Otherwise, it would have been all sorts of strife.
Yeah, you've really just got to make sure that viewers, if you are injured, you make sure that when you tell your doctors about the injuries you've sustained, you've really clearly detailed everything that's going on from the first point of call, so that then it's all there.
And Don, I work on the principle, use the shotgun approach early on, where you complain of all the injuries, because then the ones that get better, well and good. You lose nothing.
The tips that I give to my clients is when they get medical certificates, so to access benefits from the insurance company, TAC, you need a medical certificate. Just make sure that there is a record of every single injury you sustain, and if it's not there, raise it with your doctor and get them to put in a medical certificate.
And Anna, you'd get the notes reasonably early on, and you could work out from the notes if everything's in there, correct?
We can.
Yeah,
and also from the claim form is probably the other critical place that we look at to make sure that the injuries that are still complained of down the track weren't documented at the very first instance, because if they're not there from the start, that's where the problems occur.
Okay.
Yeah. The result of a Davies, Tony. So luckily in this case, the Supreme Court of Appeal overturned the original judge of first instance decision and accepted that she did complain, despite the fact there wasn't contemporaneous notes about complaints to her back and or her knee. But the judges pretty much said they accepted what she said. Her evidence was, they were told my doctor, he never recorded it, and she went on to win her case.
And I'll tell you, in a lot of instances when doctors give evidence or they're cross-examined and they say it was never complained of, or else it would have been in my notes, you find that the court finds against you because they actually say that the doctor's got everything accurately recorded.
Well, and that's a warning given to courts and judges. Yeah. The warning is that the records are just a paraphrase of what was told. So they shouldn't be putting a lot of weight on it, but sometimes they do.
There's a lot of things you've got to be careful of. All right, the next case of Davidson, you're going to give me the facts of it. Davidson and Transport Accident Commission 2015 Supreme Court again.
That's right. Now, this Davidson matter is, again, an originating motion, which is where a plaintiff goes to the county court to submit that they have sustained a serious injury. Now, Miss Davidson was a young lady at the time of the accident. She had been doing her VCAL hospitality training prior to the accident, and about a year before, she'd stopped studying and was unemployed. Then she was involved in a nasty transport accident where she sustained a very bad fracture to the left wrist. That led to her not being able to go into her chosen field of hospitality and become a chef. And she submitted that that was one of the key consequences of her serious injury application to the court. And the originating motion judge, the judge at the county court, said that he didn't agree that she had sustained a serious injury and wouldn't accept that the consequence of not becoming a chef was something that stemmed from her transport accident.
I think the judge in the first instance, Don, read too much into her becoming a chef, because that's not really the issue.
Oh, that's right. The judge at first instance looked at whether or not it was likely she would have become a chef.
That's not the test.
So looked at that's not the test. I mean, she produced evidence as just that's what I want to do, and all her studies were leading to becoming that way anyway. And her mum gave evidence as well. And
What the judge was really worried about whether she's going to be a good chef.
Yeah,
That's not the
judge,
issue.
went too
Yeah.
far. It's a judge actually went too far and said, well, look, I'm not going to accept that she would have become a chef in the circumstances.
Exactly.
But what you have to show, and what the Court of Appeal said, is that not the likelihood of becoming a chef, you have to show, it's enough to show the loss of opportunity to become a chef.
In other words, she couldn't do that.
Yeah, and
If she wanted to be a chef, she wouldn't be able to do it.
And the consequence of not being able to pursue your dream is a consequence of the serious injury.
And that was because of a wrist injury.
Tony, of course, then we can't speculate those. So
No,
it's
we
not
can't
like
speculate.
you can say you wanted to be a rocket scientist when
No,
you complete your 12 or
it's got to be
something.
within your capabilities.
Her studies were leading towards
Well, I
becoming
wasn't going to be an astronaut. I'm scared of heights. Yeah.
There
I'm
you
not going to be an
go.
astronaut. You're not going to be a brain
There's
surgeon.
still time.
Yeah.
There's still
Yeah,
time.
you know what I mean?
That's-
If you went to school and you didn't do any of those science subjects, you're not going to say I was going to be a brain surgeon.
No.
Surely.
So
Not
in,
gonna be able
in
to
this
take
case,
it.
she produced evidence, and the evidence was what she said, her studies, but also, like I said, lay witnesses. So not your expert witnesses, her mum produced evidence,
Yep,
which
yep.
all confirmed that's what she wanted to do.
Well, we've come to the end of the show again. Don, thanks for coming on board as usual.
Thanks, Tony.
Anna, thanks for coming on board today.
Thanks for
Viewers,
having
thanks
me.
for watching. Go to our past episodes, go to our social media platform and networks and everything else that we've got. Stay tuned for future episodes and always remember to stay safe.